So good afternoon everyone. Can someone tell me whether my voice is clear? And I hope this screen is also clearly visible. मेरी आवाज साफ आ रही है सबको? I hope the voice is clear, isn't it? चलिए ठीक है. Okay, चलिए. Let's start with this first question. Okay, so which section of the Companies Act requires the auditor to report whether in his opinion the financial statements comply with the accounting standards referred in the section 133? So please tell, what do you think is the correct answer? Yes, the correct answer is option number B, section 143 3E. Okay, so under section 143 3E, it says that an auditor has to report whether in his opinion the financial statement comply with the accounting standards or not. Okay, whereas section 134 5A states that the director's responsibility statement should include that in preparation of annual accounts, the applicable accounting standards had been followed. So B is the correct answer, section 143. Chaliye. Next question, again a very simple question, also the question we've discussed in the finance video also. Please tell, when a company issues shares at a premium, a sum equal to the aggregate amount of premium goes to what type of account? पिछली बार भी करा था, जल्दी बताइए. Yes, simple answer है. The correct answer is A, securities premium account. A very simple question. Last time also we've done the same. Chaliye, let's try and do this question. As per what section of the Companies Act, a company shall not issue shares at a discount except as provided in section 54 for issue of sweat equity shares. Sweat equity shares, all of you know. As per what section this provision is there? See, whenever you have a questions that is talking about some section in particular being linked, तो अगर नहीं आता है तो अगर तब भी आपको लगाना है तो you need to focus on nearby sections in place. तो उस हिसाब से you can take a guess. Otherwise, अगर section नहीं पता है, isolated है, when all of even not even one option you are able to eliminate, तो उसमें फिर आंसर मार्क करने की जरूरत नहीं है. दिस इज वेरी मच इंपॉर्टेंट. फैक्चुअल डिटेल्स जिसमें से एक भी ऑप्शन एलिमिनेट ना कर पाओ, उसमें मार्क करके अपने नेगेटिव बढ़ाने की जरूरत नहीं है. ठीक है, चलिए. सो करेक्ट आंसर इज सेक्शन 53, प्रोहिबिशन ऑन इश्यू ऑफ शेयर्स एट डिस्काउंट. तो थर्ड आंसर इज ए, सेक्शन 53. चलिए, प्लीज टेल, एज पर सेक्शन 54 of the Companies Act, the sweat equity shares shall be under lock-in period for how many years? Again, a very easy question. Please try and do this. Sweat equity shares कितने साल के लिए लॉक कराएंगे? So lock period is for how many years? Any guesses? The correct answer over here is 3 years. Okay. In sweat equity shares, it shall be lock period for 3 years. And in a company, in a year, a company can issue sweat equity shares for 15% of the existing paid up capital and issue value of 5 crores or whichever is higher. Chaliye. Next question. As per section 3 of the Companies Act, a company can issue fully paid bonus shares to its members by utilizing what type of accounts? What do you think is the correct answer? Question number 5th. The correct answer for question number 5th is that from all these accounts, they can utilize to issue fully paid bonus. So thereby E is the correct answer. Yes. Manish is correct. Subhendu is also correct. And Suraj is also correct. Very good. Please tell me, according to section 114 of the Companies Act, special resolutions passed when not less than how many of the total members present and voting give their approval either in person or by proxy, where voting by electronic means is allowed. मतलब कितने बंदे चाहिए कम से कम present and voting in order for any special resolution to be passed? So here the correct answer is simple. Whenever we talk about special resolution, so 3/4 of the members present and voting should be there in order for any resolution to be passed. So 3/4 is the correct answer. Next question. According to the Companies Act of 2013, a company can buy back its shares or other specified securities only if, what do you think is the correct answer? Options include it is authorized by its articles, a special resolution is passed at the general meeting, authorized the buyback. So here you need to understand, correct answer is C. A company can buy back its shares or other specified securities only if the ratio between the debt owed by the company and the post buyback paid up capital along with the free reserve is not more than 2. Please make sure that you remember this number also. Yeah. Sorry, here we needed to change the question. The question asked you which of the following is not correct statement. तो इसमें अगर कोई आंसर नहीं कर पाया सबको +1. So not 3 but 2. Okay. चलिए next question. According to the Companies Act of 2013, in the case of buyback of equity shares in a financial year, maximum how much percentage of the equity share capital is allowed to be bought back by the company? What do you think is the correct answer over here? Maximum buyback कितना allowed है? Eighth people are saying C. Let's check the correct answer. The correct answer is 25% of the equity shares. So in case of buyback of equity shares of financial year, maximum 25% of the equity shares is allowed to be bought back by the company. Okay. Chaliye. Next question. Where a company completes the buyback of shares or securities, whenever a company completes this process, it will not be allowed to issue further shares or securities of the same kind within a period of how many months from the date of completion of the buyback. एक बार आपने बायबैक कर दिया, उस तरीके की सिक्योरिटी आप कितने महीने तक इशू नहीं कर सकते, कुछ टाइम पीरियड होगा, उसके बाद ही आप इशू कर सकते हो. तो व्हाट इज दैट टाइम पीरियड? So here the correct answer is 6 months. As you can see, where a company completes the buyback of the shares, it will not be allowed to issue further shares or the securities of the same kind within a period of 6 months. So 6 months is the correct answer. Correct, Manish. बहुत बढ़िया. चलिए, let's try and do this next question. Under section 409 of the Companies Act, a person can be appointed as judicial member of NCLT having which of the following qualifications? What do you think is the correct answer? Whether the person should be a judge of High Court or has been district judge for at least 5 years or a advocate for at least 10 years. See, if you see the correct eligibility, you will find all three things have been given there. So if you belong to any of the above qualifications, you become eligible for judicial member. So D is the correct answer. Okay, so this is the eligibility criteria for judicial member, eligibility criteria for technical member. Please make sure that you remember, especially these years. As a district judge working for more than 5 years, eligible. As an advocate practicing for more than 10 years, eligible. Or if you are a judge of High Court, eligible. And for technical members also, a person who is a member of Indian Corporate Law Service or Indian Legal Service for more than 15 years, then you are eligible. A person who has been in practice as a chartered accountant for at least 15 years, eligible. A person who has been in practice as a cost accountant for at least 15 years, eligible. Company secretary for 15 years, eligible. So please make sure that you remember these things. Under section 410 of the Companies Act, maximum number of judicial and technical members in NCLAT is how much? Yes, the correct answer is B. Okay. इसमें ऑप्शन गलत हो गया यहाँ पर. B is the correct answer. Okay. चलिए next. Under section 411 of the Companies Act, person can be appointed as chairperson of the NCLAT having which of the following qualifications? So what do you think is the correct answer? A person who is or has been a judge, a person who has been the chief justice, or any of the qualification mentioned at A and B. So just like previously also, this is also similar in fashion. Okay. So Subhendu is correct. Okay. So C is the correct answer. Any person aggrieved by an order of tribunal may file an appeal to the appellate tribunal within a period of how many days from the date on which a copy of the order of the tribunal is made available to the person? Please tell what do you think is the correct answer? So yes, correct answer is, all of you are correct. 45 days is the correct answer. बहुत बढ़िया. Similarly, we have another question. Please try and answer this as well. Any person aggrieved by an order of appellate tribunal may file an appeal to the Supreme Court within a period of how many days from the date of receipt of the appellate tribunal order? Yes, correct. So 14 का correct answer है B, 60 days. Okay. So within 60 days, you can go, if you are not satisfied with the appellate tribunal order, you can go to the Supreme Court for an appeal. Next question, maximum age limit for chairperson of appellate tribunal is what? What do you think is the correct answer? What is the maximum age limit for chairperson of NCLAT? 15th का. As you can see, term of office of president and chairperson and other members, the present age limit is, minimum age requirement is 50 and maximum age limit 67. So thereby C is the correct answer. Yes, all of you are correct. 15th correct answer is C, 67. बहुत बढ़िया. Every company shall hold the first meeting of the board of the directors within how many days of the date of its incorporation as per Companies Act? What do you think is the correct answer? Very easy question. Please try and do this. Yes. So C is the correct answer. 30 days. Within 30 days, you need to hold the first meeting after its incorporation. Correct. Let's try and do this question. As per Companies Act, the quorum for a board meeting shall be how many members of its total strength or two directors, whichever is higher. In terms of quorum, we have this condition that you need to have this much amount of members or two directors, whichever is higher. So what do you think is the correct answer? So yes, the correct answer is A. A Companies Act, the quorum for a board meeting shall be 1/3 of its total strength or two directors, whichever is higher. Okay. Chaliye. Next is according to section 177(2), the audit committee shall consists of minimum of how many directors with independent directors forming a majority. तो minimum member audit committee में कितने होने चाहिए as per Companies Act? Yes, the correct answer is minimum members 3 with independent directors forming a majority. Similarly, when we'll talk about the nomination and remuneration committee, shall consist of 3 or more executive directors, out of which not less than how many members shall be independent directors? What do you think is the correct answer over here? Question number 19. It's also simple. NRC shall consist of 3 or more non-executive directors, out of which not less than 1/2 shall be independent directors. Okay, so A is the correct answer. Please tell me what is the maximum number of directors mentioned under the Act for a public company? Again, a very simple question and also most frequently asked question. What do you think is the correct? Yes, the correct answer is D. Sorry, C. If company wants to appoint more than 15 directors, it can do so after passing a special resolution. The limit of maximum 15 directors shall not apply to government company. Next question, as per what section of the Companies Act, memorandum of association is a legal document prepared in the formation and registration process of a company? What do you think is the correct answer? A simple answer. The correct answer is section 4. So as per section 4 of the Companies Act, which talks about memorandum of association as a legal document prepared in the formation and registration process of the company. Section 5 is related to articles of association, isn't it? चलिए, basic question, a Companies Act contains how many sections? Yes, Manish, correct. The correct answer is 470. बहुत बढ़िया. So C is the correct answer. Tell me, as per which section of the Companies Act every company making public offer or other class of public companies shall issue the securities in dematerialized form? तो डीमटेरियलाइजेशन के लिए किस कॉन्टेक्स्ट और किस सेक्शन में बोला गया? So yes, the correct answer is section 29. So as per section 29, every company shall make public offer and issue securities in dematerialized form. वो पेपर वाला ओरिजिनल issuing of shares have been ended. Please fill in the following blanks. Whenever a dividend is declared by a company and remains unpaid for particular number of days, the company shall transfer the amount to unpaid dividend account within another particular amount of days. So please fill in the following blanks. So Prabhu is correct when he is mentioning about section C. Oh, sorry, answer, option C. It says if you haven't paid the dividend within 30 days, you have to transfer it to the unpaid dividend account within 7 days after the expiry of these 30 days. So C is the correct answer. Well done. Please tell an individual auditor can be appointed for 5 consecutive years and shall not be eligible for reappointment as auditor in the same company for how many years from the completion of his term? मतलब वो कूल ऑफ पीरियड कितने टाइम का रहेगा? Yes, all of you are correct. The correct answer is B, 5 years. Okay. B, 5 years will not be eligible for appointment. The first auditor shall be appointed by the Comptroller and Auditor General of India within how many days from the date of registration of the company? Yes, Aisha. The correct answer is 60 days. Okay, not 30. The first auditor shall be appointed by the Comptroller and Auditor General of India within 60 days from the date of registration of the company. If not done so, Board of Directors shall appoint such auditor within the next 30 days. Okay, next question. Simple corporate social responsibility is defined in what section of the Companies Act? Yes. So as per section 135, the details of the corporate social responsibility is mentioned. So E is the correct answer. Okay. ये सारी details भी पढ़ते चलना with respect to the act says that every company, private limited or public limited, which has a net worth of 500 crores or a turnover of 1000 crores, needs to spend at least 2% of its average net profit for the immediately preceding 3 financial years on corporate social responsibility. ये जरूर याद रखना सारे key terms and figures. Which of the following is not an example of cash flows from investing activities? Please tell. A little bit of mixed question as well. ठीक है, कंपनीज एक्ट के साथ साथ मिक्स क्वेश्चन भी करिए आप लोग. Yes, the correct answer is E, cash receipts from sale of goods and rendering of services, which is your example of operating activities, isn't it? Next question, a company may issue preference shares for a period exceeding how many years, but not beyond 30 years for infrastructure projects. कितने साल तक preference shares they can issue? So here the correct answer is in 29th, 20 is the correct answer, D. So as you can see, a company which is limited by shares, if the articles so authorize, can issue preference shares which is liable to be redeemed within a period of not exceeding 20 years from the date of their issue under section 55. Also, a company may issue preference shares for a period exceeding 20 years but not beyond 30 years for infrastructure projects. I hope this is clear. General वाला rule भी आप लोग को समझ में आ गया, and you've also understood the specific provision for infrastructure sector. Which form shall be filled for application of director identification number? Please tell me what do you think is the correct answer. Form वाले question भी already पूछ चुका है, so they can ask. Please make sure that you answer the correct option. So yes, the correct answer over here is B, DIR 3. Okay. So as per section 153, which deals with filing of application for allotment of DIN, okay, an applicant needs to be fill this form DIR 3. Please try and solve this question. The companies can issue secured debentures for a maturity period of how many years? Prabhu is saying B. B is the correct answer. So secured debentures can be issued by the company for maximum redemption period of 10 years. Correct. According to which section of the Companies Act companies can issue debentures? अगर आपने ऊपर पढ़ लिया होगा तो आप बता सकते हो. What do you think is the correct answer? Yes, the correct answer is E, section 71. So section 71 talks about debentures and its issue. Every company which is required to create DRR shall on or before 30th April in each year invest in specified securities or deposit a minimum of how much of the amount of debentures maturing during the year on 31st March of the next year. कितना परसेंट डिबेंचर में इन्वेस्ट करना पड़ेगा? What do you think is the correct answer? 33? So the correct answer for 33 is B, as it rightly said by Subhendu. Very good. 15% is the correct answer. Tell me, against which of the following orders appeal can be filed in NCLAT? We have NCLT, Insolvency and Bankruptcy Board of India, Competition Commission of India, or all of these. What do you think is the correct answer? Yes, the correct answer is D, all of the above. Okay, so against all these orders, you can go to Appellate Tribunal. Also, please tell which of the following committee recommended for the constitution of National Company Law Tribunal. ये तो आपको bonus point मिल गया, but nevertheless, please tell what do you think is the correct answer. गलती से जल्दी से छूट गया. So A is the correct answer. Justice V.B. Iradi. Justice V. Balakrishna Iradi. Committee in 1999 recommended for constitution of National Company Law Tribunal. ठीक है? चलिए next question. A company is permitted to enter into transactions of giving loan or guarantee providing security in the aggregate up to how much percentage of its paid up capital? So yes, the correct answer is D, 60%. Very good, Prabhu. Next question. Related party transactions are referred in which section of the Companies Act? Yes, the correct answer over here is D, section 188. Okay. Yes, Subhendu, correct. So if a company is facing loss in the current financial year up to the end of the quarter immediately preceding the date of declaration of interim dividend, then interim dividend cannot be higher than the average dividend of the last how many financial years? Very simple question. What do you think is the correct answer? Yes, the correct answer is A, 3 years. Very good. Next question. As per Companies Act, every company shall hold a minimum of how many board meetings every year? Again, a very simple but fundamental question. What do you think is the correct answer? Minimum कितनी board meetings हर साल करनी चाहिए? Minimum? So yes, the correct answer over here also is B4. Every company shall hold a minimum of 4 meetings every year, but the gap between 2 consecutive board meetings shall not be more than 120 days. The correct answer is B4. A board resolution cannot be passed by a circulation when at least how much of the total members require it to be decided at a meeting of the board? It's the correct answer जो आप लोगों ने देख ही लिया, but nevertheless the correct answer is 1/3. Okay, so until 1/3 of the total strength has talked about it. चलिए. A meeting of the board shall be called by giving not less than how many days notice in writing to every director at his address registered with the company. Again, a very simple question. Yes, again, what simple the question is. So correct answer is A7. 7 days notice in writing needs to be given. So XYZ Limited was incorporated in 25th June 2018. When can it make political contributions? What is the law with respect to political contributions in the Companies Act? Yes, the correct answer is C, after 3 years of its incorporation. Very good. Okay, so if any amount is not transferred from unpaid account to the shareholder within how many years, then only it will transfer to the fund established under section 125, which is Investor Education and Protection Fund. कितने साल तक अगर वो unpaid account रहा, then only the amount will be transferred to the IPEF. Please tell. Again, a very simple question. Yes. Correct, Prabhu. The correct answer is B, 7 years. That, if the account, any amount which is not transferred from unpaid account to the shareholder within 7 years, okay, then it will be transferred to IPEF. चलिए. Next question, the nomination and remuneration committee. Again, it's a repetitive question, but nevertheless, please try. Consist of how many executive directors? Again, we've read about it previously. तो minimum executive directors इसमें कितने रहते हैं? Minimum executive directors 3, where one half shall be independent directors. A company is not permitted to make investment through more than how many layers of investment companies? Yes, the correct answer of 45 is maximum 2. So maximum 2 layers of the investment companies is allowed. Now tell me, what is the minimum number of independent directors required in a listed public company as per section 149? Again, a very simple question. Question number 46. Minimum 1/3 of the total directors. This is at least, it should be this. And the following class or classes of companies shall have at least 2 directors as independent directors. जिनका public companies having paid up share capital of 10 crores, having turnover of 100 crores or more, or public companies which have in aggregate outstanding loans exceeding 50 crore rupees. Please tell me, what is the term of appointment of an independent director? What do you think is the correct answer? एक independent director का term कितना रहता है? Yes, the correct answer is B, 5 consecutive years, because ये हम लोगों ने पहले भी पढ़ चुका था 5 consecutive years. उसके बाद cooling period भी is also 5 years. You've already seen this. Now tell me, company shall inform and file a notice with the registrar of the companies in e-form, which is what? Within 15 days from the date of appointment of auditor. What do you think is the correct answer for question number 48? The correct answer for this is for e-form called ADT1. Okay. So A is the correct answer over here. Second last question for the day. The removal of auditor firm from his office before expiry of his term shall be done by what kind of resolution or by what authority? Yes, Manish, correct. The correct answer is A, special resolution. बहुत बढ़िया. Okay, so by special resolution, only by a special resolution you can remove an auditor. Last question. The auditor shall report only to audit committee of directors of fraud amounting to how many rupees? Yes, the correct answer for question number 50 is less than 1 crore. Okay, also remember the form ADT4 for such matter they'll be utilizing. Okay, this is the correct answer. Sorry, option इसमें गलत है. It should be more than 1 crore. If auditor found any fraud of an amount rupees 1 crore or above, he can directly report. अच्छा उसमें गवर्नमेंट है of less than में he can refer to the audit committee. Okay, तो फिर correct है option. Less than 1 crore, it will go to audit committee. Above, it will go to the government. Correct. चलिए. So this is all from my side. If you have any questions, feel free to ask. जो भी clerical errors होंगे, I'll rectify it and then we'll give you the PDF today itself. आपको अभी मिल जाएगी so that you can revise these things. Okay. If you have any question, feel free to ask. Otherwise, I'll wind up the session. Nothing? Chalo. Thank you guys for joining. We'll meet in the next session.